Mr. Brown, in each cause number, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it? In each cause number, did you review the document entitled True Bill of Indictment with your attorney? Did you understand? All right, so it'll be April 16th.
April 16th.
All right, court is calling 2025 CR 012488 and 2025 CR 011031, State versus Ariststead Brown. Can I have parties announced for the record?
Joseph Stateson for defense.
And are you Mr. Brown?
Yes, ma'am.
Counsel, in each cause number, have you received all discovery? Did you review it with your client?
Yes, Judge.
In each cause number, the court will find that the state is in compliance with discovery. Mr. Brown, in each cause number, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it? In each cause number, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it? Counsel, in each cause number, did you waive the reading of the indictment?
Yes, Judge.
State, in each cause number, are you proceeding on the indictments as presented? Mr. Brown, in the cause number ending 88, you're charged with evading arrest detention with a vehicle. And the cause number ending in 31, you're charged with deadly conduct discharging a firearm. Both of those charges are third-degree felonies. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes.
In each of the cause numbers, did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes.
Counsel, in each cause number, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offenses?
Yes, Judge.
Mr. Brown, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, or re-entry. Did you understand? In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes. According
According to the plea, the cases are to run concurrently. State is taking in consideration 2025 CR 012499. And punishment is to be assessed at a cap of 6 years in the prison. There's a $1,200 fine. The state is opposed to your applications. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State? Was that the plea?
Yes, Your Honor.
And each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then in cause number 2025 CR 012488, how do you plead? Guilty, not guilty, or no contest?
No contest.
And cause number 2025 CR 011031, how do you plead? Guilty, not guilty, or no contest?
Contest.
State, in each of the cause numbers, do you have any evidence to support the defendant's plea?
Yes, Your Honor. State offers Case Exhibit 1 and all attachments of code clauses.
No objection.
All right, state, you may be excused. Thank you. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Thank you.
In each cause number, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We'll come back for sentencing on April 16th. I'll base my decision on whatever evidence is presented. Just make sure that you meet with probation. Usually there are going to be more than one meetings for you or interviews for you. One is the PSI, the other is the TAP evaluation. So usually those are on different dates. Do not miss any of those dates. Do you understand?
Yes, ma'am.
All right, thank you. Once you sign the reset form and speak with probation, you're excused.
Thank you, Judge.
Jacob Leal.
I don't know what that. Before we get on the record, Judge, I told Brandon about these. I'm promoting them at this point. I was not worried about the cold. They're called Flygo.
Oh, what are Flygos?
They are not fashionable. I'm gonna tell you that right now. But I wore, 'cause I got the matching set. So I got the pants and I got the top.
Mhm.
I wore those out in the 18-degree weather. I didn't feel a thing for 20 minutes.
Wow.
I didn't feel a thing until my feet got cold. Like those things, we wore those during the freeze. We didn't feel a thing. I could have turned off the entire heating system.
To get that for my brothers.
I'm telling you.
Okay.
Again, not fashionable, but
Well, I'm here for the warmth. I'm not here for the fashion.
I'm making this company famous because it worked.
Oh,
And
wow.
I'm easily cold. I am easily cold. I'll wear 5 layers if I need to.
Mhm.
I almost came to court in these.
Okay, to get that. All right, so we're here on discovery issues.
There's the discovery issues, Judge. And I spoke to state, the prosecutor is on the case is having car issues. She's not here.
Mhm.
But the phone dump that was talked about last setting has not been produced to defense. That's something we're still waiting on.
All right, so is that the only thing?
Nope, we also have a motion to withdraw, Judge.
Okay. So could I see well, before we do the phone records thing, let's take up the motion to withdraw. Do you have?
It was filed and accepted, Judge. It was done so before I got here, so I printed out a copy anyways.
All right. There's my stapler. Well, I will tell you in the back office, the electricity is out.
I heard.
So, do you mind if I keep this for the court and they can file stamp it?
Yes, Judge.
All right. Have you had a chance before we go on the record, have you had a chance to review the motion to withdraw?
I sent him a copy, Judge. I talked to his mother about it on Thursday of last week.
Could you talk to him about it?
I did talk to him about it as well, yes.
Okay, so you understand the motion to withdraw? All right, the court is calling 2025 CR 012576, State versus Jacob Leal. Can I have parties announced for the record for the state,
Pertaining for the state of Texas.
for the defense?
John Pettis for defense.
And are you Mr. Leal? All right, your attorney has filed a motion to withdraw. And before I ask you a couple of questions, State, do you have any objections to the motion to withdraw? All
State.
right, State, you may be excused. So, Mr. Leal, I'll just have a couple of questions for you, and it's not about the substance of the case, it's just about this motion. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Yeah.
All right, Mr. Leal, your attorney has filed a motion to withdraw. Have you had a chance to discuss the motion to withdraw with your attorney?
Yes, ma'am.
And do you understand your attorney's reasons for wanting to withdraw? One of the reasons your attorney has in here is related to your contract with the attorney. I don't know what your contract is with him or not, because this is not civil, but that's one of the reasons why he wants to withdraw from your case. Do you have any objections to your attorney withdrawing?
No.
All right, then the court will grant the motion to withdraw. Counsel, you're excused.
Thank you, Judge.
But counsel, when he's given a new attorney, whatever discovery you have, if you'll make sure that that attorney receives it.
Absolutely, Judge.
All right, you may be excused. Mr. Leal, are you going to be able to afford to hire an attorney, or would you like one appointed?
I'm gonna work on getting a court appointment. I'm working on getting an attorney, but right now, if I could just get a court appointment.
Okay.
And I was gonna ask, I'm on house arrest. And
So here's the thing, that will need to be addressed with whoever your new attorney is going to be. So do you want one appointed, or do you want?
it's my uncle.
Okay, just have a seat. We'll make sure that you get an attorney, okay?
The fluorescent lights of the courtroom hum like a death sentence delayed. Ariststead Brown sits beside his attorney, Joseph States, as judges' questions fall like hammer blows. 2 third-degree felonies, evading arrest with a vehicle, deadly conduct with a firearm, carry the weight of 10 years in prison. Brown pleads no contest. He waives his right to a jury, to cross-examination, to silence. He signs away his appeal. The state opposes his application for deferred adjudication, yet the judge defers the finding of guilt. Brown is not free. He is a ghost walking on house arrest until April 16th, when sentencing will arrive like a thief in the night. Then the transcript fractures. A new case number, 2025 CR 012576, State versus Jacob Leal. His own attorney, John Pettis, has filed a motion to withdraw. The judge swears Leo in. The reason? Not evidence, not guilt or innocence, but the contract, the money, the raw, ugly truth of a defendant who cannot pay. Leo, already on house arrest, admits he has no attorney and cannot afford one. He asks for a court-appointed lawyer, a stranger, to step into the wreckage of his defense. The judge grants the withdrawal. The attorney walks out. Leo is left standing alone, abandoned by the very person sworn to save him. 2 men, 2 hearings, one silent, one stranded, both staring into the same void where the system grinds forward without mercy. The transcript ends not with a verdict, but with a question. When the hand that should defend you lets go, what chance do you have left in the dark?